Well, let me welcome you to Abuja this morning, Monday morning. I'm sure that you can feel, if not hear, my voice a little cracked. The weather in Abuja is not friendly. The kind of cold in Abuja will query people in charge of climate what's causing it all. But whatever it is, you're welcome to Signature Morning from the Abuja studio. Weather changes, my name never changes. It's still Nwabweze Njoku, and you're very much welcome. And this morning, we are going to be looking at something that appears novel in the Nigerian political turf. Last week, the Independent National Electoral Commission declared Bright Ngene of the Labour Party as winner in the rerun Enugu House of Assembly election. Ngene was declared winner not on account of the votes cast, but on account of the failure, by whatever circumstance, of INEC to conduct election. On March 18, 2023, election was conducted into that constituency, but PDP went to court. And the Enugu electoral electoral tribunal nullified that election on the ground that the number of votes in 8 polling units was higher than the margin by which the Labour Party won that election. On 4 occasions, INEC tried to conduct a rerun. And all those 4 occasions, political actors, circumstances made it impossible for INEC to conduct that rerun. And so when INEC tried the 4th time and it collapsed again, let's not get into the details of why it collapsed. People have been accused of thuggery, of undermining the process, or trying to get advantage. That's not the issue. INEC could not conduct the election. What did INEC do? It relied on the first result and ignored those 8 polling units, which the umpire with the electoral body, not electoral body, the electoral court, let me call it the electoral court, has said that on basis of that not being included, that election was inconclusive. So, how is this rerun election? How has it become legitimate? That's issue number 1. Issue number 2, Bright Ngene is in prison. He was found guilty by a magistrate court on matters affecting his community. He was accused of 15 million naira, mismanaged or fraudulent, whatever it was. So he's in prison. 7 years to serve, but he has gone on appeal. So, if the INEC declares somebody in prison a winner, what happens to the people's mandate? Will that earn him freedom, or is he still going to serve out? If he's going to serve out, what will happen to his constituents? There are issues that I don't know, but what I've done this morning is to bring in 2 lawyers to interrogate this matter. In the United States, I'm told if you are in prison and you win election, you go out and continue. Is it applicable in Nigeria? Now let me start from my left. My left, he's not been on this program before, is Kingdom Okere. Kingdom Okere is an Abuja-based lawyer. Kingdom, you're welcome to the program.
Morning.
By the way,
Nigerians.
Kingdom, I understand, as I've just introduced you, your name is Kingdom.
Yes, that's the name.
When are we going to enter into your kingdom?
When the leaders begin to do the right thing, all of us will be living in the kingdom of God on earth. You know, God has made it so beautiful for Nigerians that we have the resources, we have everything, you know, to live in His kingdom on earth. That is when everything the poor masses can see 3 square mil.
Okay. When circumstances allow the poor man to breathe, he says, we will enter the kingdom. I also have this morning Ocholi Okutepa. Ocholi, he's a friend on this program, and we try to tear things apart and get to understand the issues. Ocholi, you are welcome to the program.
Thank you, sir.
Great.
Thank you.
Good.
Thank you.
Ocholi, let me begin with you because you're tough, I understand. I've said this is novel.
Yes.
I can't remember having interrogated a thing of this nature before. Let's start from INEC conducting the election. 4 times INEC failed, and INEC had to go back to the very result that was nullified by a tribunal. Does this have an effect on the veracity, the legality, the acceptability of this victory for Labour?
Well, the good thing is law is quite progressive. Law is not casting like a stone or a rock that cannot be moved. The law is an ass, you would hear. It now falls on who is interested or aggrieved to approach the courts. Because you see, whenever there's a novel issue, it doesn't mean there's any novelty in justice. You see, justice sometimes is that mother that waits for the issues to arise. Because if you follow the biblical story, for example, where Solomon had to preside over a matter that had never been, it is that fact that never was. The wisdom existed waiting for the fact to arise. So you see, by the time you travel from the Federal High Court or the State High Court to the Court of Appeal and to the Supreme Court, you will arrive at the point where the Supreme Court will now give you a position of law that otherwise existed, but circumstances did not permit. Because like you have said, INEC has attempted 4 reruns, 4 times. Now, if you take the matter up in court, a lawyer would simply respond. You may sit within the courtroom and say we should go and conduct the election. But by the time we file documents, for example, just saying, of the number of persons who are dead, of the number of properties that were burnt, and we demonstrate how impracticable it was, and we show that we have done this for 4 times, that's the point. On the other hand, the person who goes to court says there's a court order saying you should conduct this rerun. So it becomes a question of a court order versus the practicability of conducting the order. So you see, this is novel in the sense of the question it raises. But that is how the issues that arose in Kogi State when the Prince Abubakar Audu was just 1 pace away from victory and died. Then the party, conducted a quick primary, and Bello emerged and participated, and Faleke went to court. It appeared novel. Same thing appeared novel when Amechi was declared at the time by the Supreme Court, and after that, legislators amended the law to ensure that an Amechi will not repeat itself by the Electoral Act being amended to say, look, you cannot be declared winner of an election until you participate at all the stages. So let's recognize that we are in a developing democracy. As in, we are still young, no matter how long we think we have come. This is a 1999 to now matter we are talking about. So this, for me, is an opportunity to develop the law. Unfortunately, they may be in court when this tenure will run out. That's subject for another time, and other cases that show that this is not as novel as it seems. Not as novel as it seems. There are case law positions that would suggest to you the direction that we are going on this matter.
The direction we are going on this matter. Kingdom. How can we arrive at the kingdom legally? Because Ocholi has clearly said that it's novel, but it is also an opportunity to establish the law. But isn't it obvious that INEC declaring somebody winner based on the result of the first election isn't it a disobedience to that tribunal? Because tribunal said no, go and rerun and declare based on the outcome of the rerun. You are declaring based on that very thing you are told was not tenable in law.
They attempted the rerun as ordered by the court and found that it was impracticable to conclude the rerun. So, well, let me take it from the point of view of what the last speaker said. In one of my academic postulations, I have defined laws as contained in our statute books as inchoate, as laws that are developing, that are evolving. Those laws are given life and become full-blown laws when they have been given judicial interpretation. And judicial interpretation is can also evolve from the trial court to the appellate court to the final court of the land. And when the Supreme Court, interprets a matter that has passed through these stages of a judicial process and arrive at a final interpretation of a particular section of the law, it becomes a full-blown. That was my philosophy of what law should be from a realist, point of view. And I don't know exactly. I just stumbled into the news and how INEC declared a prison inmate, a winner of a rerun election based on the tribunal having nullified the election and ordered the rerun election. So the question is, did INEC try to conduct another rerun election and it became impracticable? And what was the circumstances under which they now have to rely on the previous result to declare the winner, the Labour Party candidate as the winner? So, but the legal issue is sacrosanct. If INEC has made a fresh declaration, that fresh declaration supposes that it is standing on the decision of the tribunal that nullified the election and has ordered INEC to conduct another rerun election. Rerun also presupposes that election has been cancelled. So it is those that were party at the previous election that will also be party candidates as the rerun election. But if it were to be a by-election, political parties will only have the opportunity to field in new candidates. So that is why it's called rerun. So at that point in time, is INEC acting based on the judgment of the tribunal that nullified the election and has ordered the rerun? And if in the course of conducting a rerun, the rerun also proved to be inconclusive, and how it now happened that they relied on the previous result, I don't have the actual fact. But what I know is that Section 66 of the Constitution is very clear as to who is qualified to be a member of the House of Representatives or a member of the Senate of the Federal Republic of Nigeria. So if this man has been convicted, not that is on awaiting trial, of course you know that somebody on awaiting trial can also be in prison custody. So, but if he has been convicted by either a magistrate court or a high court and he is on appeal at the court of appeal, why do the INEC has the constitutional power, or does he have the constitutional right to be declared a winner of the election?
We'll come to that.
What I want to focus on, the constitutional implication of what INEC has done.
Okay, we'll come to that in respect of his being qualified or not.
Did INEC know that he is now in prison custody? Has any of the parties gone to serve INEC CTC of the judgment of the magistrate court or the high court that sentenced him to prison? So these are the questions to ask.
We'll come to that because that's the second part of this conversation. Actually, does attempt and failure, I attempted, does it justify not obeying to the letter what the court has ordered? I attempted and I failed.
I love your question, because law does not exist in a vacuum.
Simple.
Law is for the living. It's just like, let me go to biblical injunction. When Jesus healed somebody on the Sabbath and they said, on the Sabbath? He said something to them. He says that the Sabbath was made for man, not man for the Sabbath.
Let me give a sentence from you, lawyers.
Yes.
You say that the law is blind. It goes where it ought to go.
Okay.
Now you are giving the law an eye to see.
Oh.
So making it blind.
The law has opportunities to have eyes that see. For instance, when you get into constitutional provisions and exceptions to those constitutional provisions, the law will have to remove the blindfold at those times. For example, when you come to declaring state of emergency, Are we not experiencing some things in Nigeria and talking about who is right, who is not right? You now go to the law. Why were you able to declare state of emergency in a state? I know that's not the conversation. I'm just giving you exceptional circumstances. Then you have exceptional circumstances or where there's a state of war and the president does not have to wait for the Senate to convene to take certain decisions. You see, under the emergency rule, when you go into those, you are seeing that the law itself is not so cast in stone, like I said at the beginning, that is not amenable. So here is the deal. INEC cannot be said to be held or cannot be held
hostage,
hostage
by law.
Exactly, or culpable. Did INEC in fact fix a date for rerun in the affected polling units? And let me clarify an impression on the conversation we are having here. The election was not cancelled. The election was declared to be inconclusive because so and so polling units did not have the opportunity to exercise their
franchise. Now do they have?
Now, that's the point I'm coming to. So I have said, go and give them the opportunity to exercise that franchise. The question is, this order has different participants to it. It applies to not just INEC. INEC is to conduct, electorates are to vote, security personnel are to provide security. That means this order is multifaceted as to who should comply. So the question is, if you want to sue INEC for attempting 4 times and saying it has become impracticable, and we are going to rely on the existing results so that we do not continue, the practical questions that arises and which will lead to the conversation as to who is right, who is not right, is INEC. What did you do? INEC will file an affidavit. INEC will show you how they announced the election on the date it will happen. INEC will show you all they deployed to have the election on the day it will happen. INEC will, even if they want, give you the budget of what it costs the Federal Republic of Nigeria to conduct this election. Then the question becomes, what now happened when we went to the field? When you begin to see that, you see that the different actors that should play a role, even the Federal Republic of Nigeria should be sued. Why? The Federal Republic of Nigeria, the commander-in-chief is commanding-in-chief even there. The Inspector General of Police and his men, who are supposed to ensure that this election can hold. So this is a question too practical to be sentimental about. So we cannot just say there's a court order, there's a court order. If there's nobody in society, where will court order apply? So these are the questions. Whether the propriety of whether INEC should have in fact relied on
the initial
result or go to court and say it's impossible to obey your order. Those are legal questions that can now come up. But to say simplicity that INEC is wrong, come on. We live in this very country. How many persons have we lost to electoral violence or issues related to election? Let's be very practical about it. Did INEC in fact obey the order of court? They did. Then they met a roadblock. And in their view, they now came up with the best possible solution that they thought they would have. And if you look at Adeleke and Oyetola, if you look at the fine lines of that judgment, you will see indeed that when rerun is ordered, INEC can only conduct it as much as practicable. In this case, the question I will have is, did INEC indeed, in fact, do the best they would within their power to conduct this election? The answer is yes. The answer is not just yes. The answer is yes 4 times. So perhaps my law is not that deep.
No, Kingdom. Ocholi has raised certain things which are of great interest to me, and that includes, and I'll raise it for them. Is this not going to open a floodgate to justify failure to obey the court order to the letter by mere attempting? I attempted to arrest that fleeing criminal. I attempted to pay my debts. Attempting then becomes an excuse to allow what is wrong to slip through. Attempting, is it an answer to a court order?
Well, I agree partly with my colleague, some of his submission. If INEC has complied with the order of the court to say conduct a rerun, and there's no what they call notice of election, and they have given notice of a rerun election, and they've gone ahead to print ballot boxes and deploy their staff to the various polling units where rerun is to be conducted, and it became impracticable, or maybe voters didn't come to vote, or politicians unleashed mayhem on the INEC ad hoc staff, and maybe on even voters, and they were not able to vote, and it became impracticable to conclude that rerun. INEC will go ahead and declare the result and return a winner based on what they have, because it's a continuation of the previous election that is now declared inconclusive based on the judgment that says, hey, this and this and this polling units, result we are not so it's a continuation of that result. So we are in complying with the order of the court to conduct a rerun, and they have set the motion, the process in motion to conduct a rerun, and their staff has gone ahead. So, and it became inconclusive to gather results from those polling units that
or whatever else that made it
to
difficult
be able to add to what they have. So INEC will not turn themselves to voters or to now. So what INEC will not do is to return what they have based on what they have already. If it become practicable or impossible to gather the vote and result of those polling units that have been specifically ordered for the rerun. So that is what they do. But the legal question now is, did INEC have notice of the fact that this person has now been convicted? If they have notice of
again,
that,
I'm coming to that.
That is the issue. That is
okay,
where the constitutional provision.
Okay.
So, but whether or not INEC has complied with the order mandating them to
very good
to conduct a rerun election, and if they have gone ahead to issue notice of election, practically
it
came
to
the polling units to conduct the election. They have complied from my own.
Very quickly, Ocholi Kingdom. I want to ask just one last question on this matter. Has INEC complied with the court order?
INEC has partly, in fact, let me use the order, what led to the order.
I just want to, go ahead.
Yes, the election was inconclusive and INEC was said to conclude it.
Yes.
INEC attempted to conclude it, and INEC has an inconclusive process on their hand.
Good.
And INEC decided that society cannot continue like this, having attempted. And INEC has
Actually, my question is simple. Has INEC complied with the court order?
INEC has complied.
I think
has INEC complied with the court order?
Substantially, they have complied.
Well, the consensus said that INEC has done what the court ordered. The circumstances that made it difficult for them to get results from those 4 attempts are a different matter altogether. This is Mabuja, this cold Monday morning in the capital city. We'll take a short break, maybe drink warm water, and we're back. Please stay with us.
Every second, every minute, every day, news is breaking. Events occur, and there are new developments. At Signature TV, we follow these stories objectively, bringing all sides without bias, explaining the complex issues, breaking down the numbers, and investigating the issues behind the news. Anywhere and everywhere, near or far, wherever the news is, we will be there. Signature TV. News in your pocket.
You are welcome back. We're still in the studio with 2 of my friends, Ocholi Okutepa and Kingdom Okere. Now, by the way, I had a senior prefect in my secondary school. His name was Okere. At the end of this program, I asked him whether Okere is his father. But for now, in this second segment of this morning's conversation, I raised the matter of Bright Ngene the winner of this election under the platform or on the platform of Labour Party is in prison custody. A magistrate had found him guilty in a case of 15 million naira mismanagement or misuse of community fund. So he is said to be a 7-year sentence, but he's gone on appeal even though he remains in prison. It was from the prison that he won election. First of all, that's a new one, isn't it? Ocholi. Yeah, I know I keep asking you those questions, but that is where Kingdom is very interested. We get to get all the information from him. This man, by the records of the courts,
Yes.
at the magistrate level,
Yes.
has been convicted
Yes.
and sentenced to 7 years in prison.
Yes.
The conviction stands, but he's challenging it.
Yes.
Does his challenging it
Yes.
on appeal remove the fact of his conviction?
Okay, I love your question, because you see, when you ask the question this way, we now have to travel into law. You have asked me the question from fact.
Yes.
Right? But there is the legal aspect of every fact. We said earlier, and it is not in doubt, that we are dealing with a rerun in some polling units.
Yes.
Which establishes the basic fact that this election, by case law, is a continuation. Go back to Faleke's case, go back to Yetola. It is not a fresh election.
No.
So what it throws up is, what is the actual date of the election in question? The actual date will not relate to the rerun date, because the rerun is an attempt to conclude an election that otherwise started on another date. So the real point here is to look at those dates vis-a-vis the constitutional provisions as it has to do with qualification. So when you look at section 66, section 107, you are dealing with conviction within 10 years to an election. So since we are dealing with a date matter, when was the election in question?
March 18, 2023.
2023. When was the conviction or the sentence? The conviction and sentence of Mr. Ngene? When was it passed? And the answer would be that the conviction happened after the effective date of the election. That means, just like my learned friend said earlier, when you are talking about a rerun in this sense, it is the parties who were qualified in the first place who would participate. So in the eye of the law, Mr. Bright is still in 2023. In the eyes of Nigerians, and in fact, Mr. Bright is in prison. So the electoral law will see him where he was in 2023. Otherwise, you raise another legal issue of disqualifying a person who was in fact and law qualified as at when the election was conducted. So as we speak, there is no question of conviction affecting the original state of when the election was conducted. The question you can now ask is to go to other provisions of the Constitution to see if a person who is holding office and is convicted and has an appeal can be said to automatically, by the provisions of the Constitution, vacate his seat. That is a real question we should be answering.
Okay, I know. Kingdom, I'm sure this is your tough.
It's not about
this is your tough.
My learned colleague has taken his view of the law from his own part. Of course, the law is very dynamic and has several perspectives. Even judges, delivering judgment, delivers their judgment, interpreting the same sections of the law from diverse perspectives, So the Constitution is not too far from us. Section 66, subsection 1, C and D. That was the two sections he referred to. Maybe I can just quickly read it. He's talking about disqualification. First of all, section 65 is about qualification. You have to be a citizen of Nigeria and have 25 years or 40 years and all those. There are a lot of disqualifications. Talking about the section 66 means that you are not even qualified to participate in that election.
At all.
So, disqualification said no person shall be qualified for election to the Senate or House of Representatives if, let's take C and D, that's what concerns us here now. He is under sentence. He is under sentence of death imposed on him by any competent court or tribunal in Nigeria, or sentence of imprisonment or fine for an offense involving dishonesty, like you said, 15 million fraud from his community, or fraud, or for whatever the so-called, the constitution says, whatever so-called the offense that he has been sentenced, or any other sentence imposed on him in such court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court. He is under sentence. He shall not be qualified. Now, this said, within a period of 10 years before the date of the election. Now, before the date of the election to a legislative house, he has been convicted or sentenced for an offense involving dishonesty, or he has been found guilty of the contravention of the code of conduct. So now, the first leg, section 166(1)(c), he said that he is under a sentence of death. Now, because this is a novel question, that is what during your introduction.
Yes.
I would want to see the judiciary do justice when either of the parties in this rerun election has gone now to approach the court formally, probably with CTC of the judgment of the, to ask whether or not this person has been declared winner, is qualified to have been declared winner. So now, if there is a rerun election that has been ordered, it means that nobody has been declared winner in the eyes
before
of the
then.
No, the tribunal has qualified and say conduct a rerun. It means that the election
nobody has not been. There's
winner. No winner. Go and conduct a rerun in specific polling units and come out with the final result. That means the result of that election that started in 2023 has not been concluded. It's still in the making. It's still in the process. It's still being breathed. You can breed, some wines can be brewed for 30 years. Then you can see Glenfiddich or a wine that says 25 years, 30. I don't want to mention so that I don't advertise brand.
Yes.
So it means that the process of making him a member of the House of Representatives is still in the process. It is through the vote of the electorate, which commenced in 2023, and by judicial process, what was concluded in 2023 was nullified, and the court have now said go and conclude. So that means the process is still as fresh as the wind. There is no member representing that constituency in the House of Representatives as of today. So he is still, all the parties, all the candidates in that election are still in the process of being declared members of the House of Representatives. So he is now caught in by the web of the law. He is now under a sentence imposed or imprisoned by a competent court or tribunal of law in Nigeria. Even though the process, that is my own jurisprudential, if I were the judge to, like I've said in my introductory, even a section of the law, several judges or 7-man panel of justices of the Supreme Court interpret it from various canons of interpretation. So even though this process of making either of the parties, either of the candidates of any of the political parties to that election, even though the process of making either of them a member of the House of Representatives, even though it commenced in 2023, they are all still in the process of being declared winner of an election that commenced in 2023. So that election has not been concluded.
In other words, his status as a convict or no convict still subsists, even though it happened in the process of this election.
Declared election. That is my jurisprudential analysis of it. So I am saying that Section 166(1)(c) caught him effectively. So what Section 166(1)(d) is saying that if I was convicted and I served for 6 months before the 2023 election, and I have finished serving and came out to say I want to contest that election, I am already disqualified, because I just came out from prison 6 months ago, or even I came out from prison 9 months ago. The Constitution says 10 years. So, but if I came out from prison 11 years ago, earlier, I can participate in that election. I am no longer automatically, constitutionally disqualified from participating in the election of a member of House of Representatives or Senate if I was convicted 11 years ago. But if I was convicted 6 months ago, 9 years ago, I am automatically constitutionally disqualified from participating.
If I'm convicted in the course of the election.
In the course of election, that is what I'm telling you, that he is
caught up by this.
By Section C. From my jurisprudential analysis of what ought to be interpreted on Section 66(1)(c) of the 1999 Constitution, because all the candidates in that election are still in the process of being declared member of the House of Representatives.
Can I jump in?
Yeah, please do. Okay, go ahead.
First of all, we're dealing with the House of Assembly.
Yes, State House of Assembly.
Yes, so not House of Representatives. Yes. I know that the provisions are
House of Assembly.
The House of Assembly is not the House of Representatives.
House of Representatives.
So let's get that first.
Okay.
Number 2, you see, when you speak about jurisprudence, you need to look at that law again. The order of the tribunal did not order the processes leading up to an election to be reinvestigated. Hope you know, announcing date of election is a constitutional provision and also contains the Electoral Act.
Of course.
Hope you know the issues of qualifications, sieving of qualification, is also a constitutional matter and also provided for the Electoral Act, which has constitutional flavor. Hope you know the time to even challenge on issues of qualification. You see, when we talk about time, we cannot use sentiments. Time is time. The provisions you have read, which is in pari material with
Section 107, that was
says before the election. You are talking about 10 years leading up to the election. So what is the order of the tribunal?
What about the C?
Does the order of the tribunal, I can read C. Can I use your constitution so that I'm not using my
107C.
107C. Let's look at it. He is now, no person shall be qualified for election to the House of Assembly if, don't forget, I already referred to when this election is. And you spoke about jurisprudence and case law and the opportunity for the court to decide.
Yeah.
If you read Legality and INEC, the Aldu case, which you up something quite not exactly similar. The Supreme Court said it's a continuation. There's nothing new happening. So forget the subsequent date. You are relating it back to the date of the election. As at the date of the election was ABC, the state of affairs. See, he's under a sentence of death imposed on him by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine. The question is, at what point is what I am saying. I know we can speak about jurisprudence, of course. My learned friend knows that is how we do it until the court decides. And the Supreme Court has said that they are final, not because they are infallible. They are infallible because they are final. So that is why Supreme Court is infallible. All right. So when we get to the Supreme Court can now say, all of you keep your argument aside. I have made a decision. But it seemed very clear, constitutionally to my mind, that if I follow the same Supreme Court in Faleke and INEC, and I apply it to this case, the relevant question in issue would be, did the tribunal actually cancel the election? The answer is no. The tribunal retained Mr. Ungene's votes for the polling units that were well conducted. Number 2, did the tribunal say, oh, go and check their qualification? The answer is no. Because when you have a rerun situation from inconclusive situation, it is go and finish what you started. If the tribunal say go and finish what you started, what date is he referring to? That means what we are doing in 2025 has everything to do with what we did in 2023. That means the parameters we are looking at as to who can participate is the condition of 2023. So if we import anything, now this is clear, but if you do not follow the analysis I just gave, you will apply this as of now. So here's the question. Somebody has to go back to the tribunal to now arrive at a decision to say your vote that you in fact got in 2023 is now invalidated by a decision in 2024, which for me is absurd. It doesn't even pass the reasonable man's test. How can you nullify the past based on the future? You cannot do that. And that is why when you look at even the political situations in Nigeria where a governor in fact serves before a decision of court removes him, you do not invalidate all the things he did on behalf of the state. He in fact did it. The state is bound by it. Why? Oh, you want to go and reverse every contract? You will not do it. All right? So he's lost the place, but there is an institution that survives him, and that institution continues. So when you look at this situation, you will ask the question, look at Legality and INEC, look at this provision of the law, look at the fine lines of the judgment of the tribunal itself. What did he order? Investigation into qualification? New standards of qualification? No. He says, look, you had so and so vote by which you actually won the election. But because so and so polling units were not factored, I am now asking you, go and finish those ones. So the question I have for real in this jurisprudential conversation is, would we not be reading into the tribunal's decision fresh things the tribunal did not say if we reopen the question of qualification based on a 2025 position, applying it to a 2023 position? I do not think that would be a good way to proceed.
Ochula, I'll come back to you, but Kingdom, what he has just said makes me to ask you this question first, please. If I have been elected, or yes, let me, because that's his argument. If I have been elected and I commit armed robbery and I'm found guilty, maybe I'm sentenced to 5 years in jail, because this seems to be what is playing out. Am I qualified to keep holding on to that mandate?
Well, sir, first of all, when I before I made my analysis, I stated categorically that I would be very glad to see one or two of the candidates in this election, to go back to court, to approach the court to say,
you said so,
these are the issues that we think, that desire judicial interpretation and intervention. Because the tribunal, like my colleague said, didn't go to the question of qualification, or
it wasn't an issue,
or it was not an issue before the tribunal whether this person has been sentenced to prison for dishonesty, and is now caught by the web of section 107 subsection 1. And
again, and then that sentencing did not precede the election.
No. I still maintain my position. Okay. So, but what I'm saying that at the time the tribunal delivered the judgment and ordered for a rerun, the tribunal didn't, the issue of this man, whether he has been sentenced and is now caught by the web of section 1071.
That did not arise.
So first of all, I thank my colleague so much. I was thinking it's a House of Representative election, because I didn't really read details of this thing. So it's State House of Assembly. So it is guided by section 1071, but they are still the same. 107 subsection 1C and D is almost the same thing with 1066 1C and D for the House of Representatives. So now, what we still maintain is the fact that election that commenced in 2023 and a winner was declared, and there were several litigations that led to tribunal nullifying, not nullifying, saying election is conclude here and there, means that a winner has not been declared. They are still in the process of being made members.
They are finding a winner.
They are still in the process of, I mean, the candidates that are participating in the election are still in the process of being declared members of the House of Representatives. And one of them, and eventually he's the one that has been declared. And I'm saying that Section 1071C would be applicable. And that will only happen if either of the parties to that election has gone back to approach the court. And like my colleague said previously, there might, you won't be surprised that they will be in this litigation, and the last span of the 10th National Assembly will exhaust. So the fact remains that laws are activated by seeking judicial interpretation. So issues that we are not found in a judgment that we think that needs clarifications, it's only the court of law that has that right. All what we are saying here are opinion. Legal opinion. You still make the opinion before the law. Opinion as legal practitioner. Yes. So it becomes the law if you are returned as a counsel, or if any other lawyer is returned as a counsel, and he has now made these opinions as submissions before the court, for a court of competent jurisdiction to now say this is what it is. I say what is what I have interpreted this section to be, and it will snowball from the trial court to ultimate the Supreme Court, which also my colleague reminded us of the infallibility of the Supreme Court. But then, because they are final, they are what they are. So it requires judicial interpretation. The case of a delegate that he has so much referred about, I wrote legal opinion, in that matter, and I attempted to see how that legal opinion, would, go into the debate at the Federal High Court, through either of the council. But because I believe that as at the time, Aldu died. Yes. The man that should have stepped in was Faleke, and that is what I believe is the true position. Unfortunately, the Supreme Court has laid that to rest. Is final. Okay, so let us not the Supreme Court. Okay. No, there was a question I asked him because I'm told that I just have only 2 minutes to actually. Yes. Listen. I want to jump in on that question. Because you don't have to if I am, thank you, go ahead. Yes. We have precedents in this country. Darie served his time in prison. Kalu or Kalu, although he finally came out and finished it in fact. You see, the Constitution does not provide for an automatic loss of the seat. It doesn't. It has to take legal process, and that legal process is often hampered by the existence of appeals. How did Darie do it? You kept appealing, because I'm already in the seat and you have not convicted me, and I have a right of appeal. That means until the Supreme Court declares that what the High Court or Federal High Court of Appeal has even affirmed, it is not final. Unfortunately, in this country, it can take you to a gentleman was sentenced to death at the Court of First Instance in 1980. Unfortunately, it took him until 2000 for the Supreme Court to set aside that decision, and he regained his freedom. But the man would not die. Why? 20 years does not matter. What matters is that at the end of the day, the final court that has a final say that you should not die. So here's the question. If people vacate their seats because there's a conviction while they are on seat and they end up winning the appeal, how can the state remedy it? So, you see, once there's an appeal with a person sitting on his seat, he can run. It's not just in America like you alluded to at the beginning. I have a seat. The person is convicted. The person is in prison. The person has a valid appeal. The appeal is a constitutional right of appeal. So that appeal will sustain his seat. It will sustain his seat. And let me still repeat. Section 1071C and D relates to qualification before the date of the election.
Thank you very much. I think I've just returned. No, I've not returned yet. I'm still in school. School with the two.
That's school fees.
Well, they're asking me to pay fees for this school, but I also think that you've gotten so much from this conversation this morning. We've been talking about Bright Ngene's victory last week in the rerun Enugu State House of Assembly election, and that there were no figures. All INEC did was rely on the results
existed
in the results of the first election of 18th of March in 2023, which result a tribunal had said made it inconclusive and ordered INEC to go and rerun in those 8 units, which was not done by circumstances outside of the control of INEC. And the 2 gentlemen who ought to know and who know say INEC has obeyed the court of the law, the order of the tribunal, and so whatever they announced should stand before the law. I don't know whether any of the gentlemen will approach a court to argue their case, but for now, Bright Ingene, by the conversation this morning, stands elected as the representative of Enugu South in the Enugu State House of Assembly. How many more years does he have? Just about less than 2 years to represent the people. All I can do now is, Kingdom, thank you very much for coming. Thank you very much. And that's the program for this Monday morning. Please join us tomorrow for another edition. My name is Nwabweze Njoko. Good morning.